Welcome to this edition of Inside America's Boardrooms. I'm TK Kerstetter, and I'll be your host for today's show. So last week we had a great discussion. We had the chance to talk about M&A in the COVID-19 crisis, and we sort of talked about opportunities. Well, today we're going to talk about should boards consider poison pills during the COVID-19 crisis? And this is looking mainly at companies that would be more undervalued or, if you will, weak targets for somebody to take advantage of. So joining me again to look at the black cloud side of this is Amy Simmerman and Doug Schnell, who are partners specializing in corporate work for Wilson Sonsini, Goodrich, and Rosati. Welcome, guys.
Thank you.
Thank you.
So again, last week we looked at taking advantage of strategic opportunities in the market and sort of what boards should do. Today we're going to look at the opposite. We're going to sort of take into account companies that whose values have not been restored, who might feel a little vulnerable. And Doug, it's interesting that discussions on rights plans and poison pills have reemerged as part of this environment. I can only assume that part of that is because, again, of the serious stock drops that many companies' stock endured. First of all, is that correct? And second of all, why are investors seemingly more tolerant now? Because it was just several years ago that everybody was up in arms about rights plans and poison pills and how they were used and whether they got shareholder approval, et cetera, et cetera. So talk a little bit about sort of the current environment.
Yeah, really good questions. On your first question, we have seen an uptick in the adoption of rights plans this year. We've sort of call it as March 1st onward. There's been approximately 60 adoptions of rights plans. A number of other plans have been extended or modified, but roughly speaking, 60 adoptions, which is more adoptions in that period than there have been in numerous prior years. A lot of companies are thinking about it. And I think the primary companies that put one in place were ones where they saw their valuation just collapse in the March timeframe, especially. You had restaurants. Dave & Buster's is a good example of one that put something in place where the value of the company just evaporated as they had to close all the locations. And there became a real fear that, gosh, at such a low valuation, somebody could come in and acquire a really meaningful stake very quickly at a very low price, and we wouldn't really be able to do anything about it, or we'd be stuck with that for a long period of time. And so I think a lot of boards felt they needed to do something. Some boards felt they needed to do something. Ultimately, a rights plan is not a one-size-fits-all situation. Adopting a poison pill is something you got to think very carefully about. It's candidly not the right decision for most companies. And I think investors are still very wary of them. I don't think there's a whole lot of situations where investors are just saying, COVID-19, you get a pass on everything for the next year or two. I think they're still taking a hard look at rights plans. Williams Companies had a plan that they put in place with a very unusual 5% trigger, and ISS whacked them pretty hard as a result of that. So, even if you're thinking about a rights plan, it's not a free-for-all, and you still want to keep it within the bounds of sort of market practice right now.
So, Amy, this falls back on the board, particularly if management sort of is coming into a meeting and recommending this is what they think they should do. So what are sort of the governance and fiduciary duty considerations around rights plans, and what advice would you give boards prior to taking any action on something like this?
Sure, and you're right. The board's completely at the center of this decision, and this is very much a decision the board has to make. As Doug intimated, it's a serious fiduciary decision. From a legal standpoint, when boards decide to adopt a pill, the courts take a closer look at what a board does. So normally you want the protection of the business judgment rule And that does apply to your typical day-to-day decisions by a board where a court won't really intervene absent some concerning facts. But when you adopt a pill, it's not business judgment rule territory, generally speaking. A board is subject to a heightened standard. Now, it's a reasonableness standard, to be clear. Essentially, what a court looks at is, did a board reasonably perceive a threat to the business? And did it respond reasonably and proportionally? So as you can tell from that test, it's something that boards can survive and show, but the court does take a closer look. And so setting aside the legal standard, what it boils down to is the board wants to have a thoughtful, deliberative process where it thinks hard about adopting a pill, and you have a good record where you work hard with your legal advisors, typically a financial advisor. You understand the pill, you understand why you're adopting it. And if you have that kind of careful, deliberative process, you should be on pretty good footing, at least for Delaware purposes. Something I would note here is that as long as you approach this responsibly as a board, Delaware law is fairly friendly to boards adopting a pill. We've had cases since the mid-'80s where the courts have been fairly supportive of it as long as you do it responsibly. I think, as Doug suggested, where you might have to particularly pause as a board is to think about how proxy advisory firms will respond. How will your investors respond? How will things look for you at the next stockholder meeting? Those are the places these days where boards might hit a little bit more friction when they think about adopting a rights plan.
And Doug, the institutional investors, the BlackRocks, Vanguard, State Streets, T. Rowe Price, how are they responding? They have sort of followed their independent path these days, and they seemingly control such a significant percentage of some companies. What's been the reaction on their side to the adoptions or the suggested adoptions that have occurred?
It's a good question. I think most of them have sort of given some deference to management in this time. I looked recently, the average duration of rights plans adopted since March 1st is just a little over a year. I think, generally speaking, investors are, while not excited, somewhat comfortable with the idea of a short-term rights plan, so long as the board and the management team provide sufficient justification for why they need to put it in place. I think usually you'll get some deference on that. Again, unusual terms or being sort of outside of the normal bounds of market practice are going to cause greater concern. But I think, there's a perception out there among the largest institutions that you got to give managements and boards a little bit of latitude right now to think about, okay, in the short term, here's what I think is the best way to protect the company.
So there was a push, I know, several years ago to make it have to receive shareholder approval. Where does that stand? And is that just a nice to do these days, or is there some regulations around that?
No regulations. There is a strong policy by ISS for plans less than a year, over a year, needing to be subject to shareholder approval. Of course, as with everything ISS, that's advisory only. But the implications for board elections in the future, if you don't follow ISS procedures, can be pretty severe because directors will be subject to against or withhold votes. Now, ISS emphasizes that decisions on rights plans for them are always case by case, which implies that you might be able to convince them that it was okay there wasn't a shareholder vote on it. But generally speaking, if you're looking at a plan that's over a year long, you need to think very hard about putting that up for shareholder ratification at an upcoming annual meeting.
Yeah. So, Doug, this is really your space. So I'm going to ask you to look into your crystal ball for a moment. And with what's happening again, and with this uptick during this environment, when you look at sort of the future, or hopefully a post-COVID-19 period, notice I say hopefully, what do you see? What do you see happening around this rights plan, poison pill stuff? Do we revert back to COVID, or do you see some kind of changes coming out about around this that we'll see different structures cropping up?
Yeah, it's a really good question. I do think the market will settle back down and we'll go back to the poison pill actually being somewhat unusual. These are certainly unprecedented times. You saw an increase in adoption, in the financial crisis. It's not surprising you're seeing an increase right now. But as the economy gets back to normal and as valuations begin to settle out on a more fundamental basis, I think you'll see companies not feeling like they have to rush to put a rights plan in place. And you'll see us return to historical average on the use of rights plans, where they really will be focused again on unique situations, right? A hostile takeover, something like that, where the company just has to respond.
Well, I want to thank you both for taking the time. We've had the chance to look at the opportunity side that COVID-19 creates, and we had the opportunity to look at the risk side as well. And if there's one thing that I could leave with our viewers, it's reemphasizing Amy's points about process. I can't tell you how many different facets of their fiduciary responsibility boils down to process, and the process that somebody goes through. It certainly seems like the Delaware courts, it's okay to make a mistake. It's not okay not to do due diligence, with that. So, Amy, I'll give you the last word here. Process and execution of that process seems so important to, again, getting the business judgment rule and making sure that from a liabilities perspective, that boards are sort of relatively free and clear.
That's exactly right. The Delaware law answer so often boils down to that: a good process, managing conflicts of interest, having really good minutes. And fundamentally, what you want to do here is act in the best interest of the company and its stockholders, and show that you did that responsibly and thoughtfully. And of course, you have to take into account all the different types of factors we talked about, but the process is really important.
Well, again, thanks to both. And that will conclude this edition of Inside America's Boardrooms. We hope you enjoyed the show. We'll be back again next week when we take another look at a critical topic that'll help you be a better board member or committee member. So we'll see you then.